I'm Cynthia Rowland, and this is episode 131 of EO Radio Show. I'm surprised that in the 3 years and 130 episodes I've recorded for this show, I haven't yet devoted one to grant agreements. Well, better late than never, I guess. I've been writing a lot of grant agreements lately, so the details of these agreements are top of mind for me. In this episode, I'll talk about what makes a good form for use by grant-making charities, and I'll include some tips and observations on common and some not-so-common provisions. Welcome to the EO Radio Show, your nonprofit legal resource. Brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. So, let's talk about grant agreements between charitable organizations. In this episode, I'm not going to address grants to individuals, such as scholarship grants, nor am I going to talk about the special requirements that come into play when a charity makes a grant to a for-profit organization. Those are less common and have special requirements. While there definitely isn't a one-size-fits-all format for grant agreements, there are some key provisions that should be considered each time a substantial grant is made. I'll first talk about general support grants to public charities. Then I'll talk about a form I like to start with for project-specific grants made by private foundations or public charities to domestic operating charities. I'll wrap up with some observations about special concerns for endowment grants and some ideas about naming rights that are associated with grant agreements. So also, by way of background, I'm going to assume throughout this episode that the grant-making charity, which I'll refer to as the grantor, is organized in the United States and is recognized by the IRS as an organization described in Internal Revenue Code Section 501c3. Let's also assume that the grantor annually has an independent audit by a CPA firm and so is attentive to internal procedures that follow typical grant review and approval procedures. So let's start with the simplest form of grant agreement, one that covers a single payment general support grant to a domestic public charity. These grants can be drafted as a simple letter or in a contract format. Either way is fine. When the grantor itself is a public charity and the grantor has already satisfied itself that the grantee is recognized by the IRS as a public charity and is current in all applicable state filing requirements, the grant really can be made in a single one-page letter that awards the grant and is accompanied by the check or simply requests wiring instructions. It's not necessary to have the letter countersigned, though most grantors do want some sort of acknowledgement of receipt to show their auditors. In some circumstances, the grant letter might include a statement that the grant funds cannot be used for an illegal purpose or to fund terrorism or violence, if there's any concern at all that including that language is important to either the grantor or the grantee. But other than that, for trust-based grant making, this simple award letter for a general support grant that's made in a single installment can be perfectly fine. Grantors that are private foundations, however, often want to include, even in their simple general support grant, some typical provisions, such as provisions that prohibit use of any portion or proceeds from the grant to carry on propaganda or attempt to influence legislation within the meaning of Internal Revenue Code Section 4945D1. They may also want to prohibit use of the funds to influence the outcome of any specific public election of any candidate for public office, or to carry on directly or indirectly any voter registration drive within the meaning, again, of Internal Revenue Code Section 4945. Sometimes they include the provision that prohibits use of the grant funds to make a grant to an individual or another organization unless the regrant is specifically described in the purposes of the grant. The grant agreement may also prohibit use of grant funds to undertake any activity for any purpose other than a charitable one as specified in Internal Revenue Code Section 170C2B. And finally, to prohibit use of the funds to provide material support to any person or entity that engages in violent or terrorist activities. Often the private foundation's simple form of grant agreement also requires the grantee to notify the grantor of any organizational changes during the term of the grant and any changes to key personnel or changes in the grantee's tax-exempt status. Finally, these simple private foundation grant agreements often include a provision that says the grantee should not publicly acknowledge the grantor by any means including but not limited to commemorative materials, written product, website announcements, and the like, unless the acknowledgement has been pre-approved in writing by the grantor. So now I'm going to move up to the next level of complexity, and that's the typical terms in a project-specific grant. The key features here often include a restricted purpose, possibly periodic payments based on deliverables, and interim and final grant reports, and many other things. So I'm going to walk through now my preferred template for these kinds of grant agreements. So what I'm going to discuss here are the form grant agreements that I like to use as a template so that we cover all of the potential issues that need to be covered in a grant agreement. So here's what my template looks like. First, we start with an introductory paragraph. This one that I'm referring to happens to be written in the form of a letter. It can be a very formal grant agreement. But my preferred template is a letter format with an introductory paragraph that awards the grant and that describes the specific purpose of the grant agreement. Here, for these project agreements, I want the grant letter to be very clear about the goals, objectives, outcomes, and measurements that are going to be used by the grantor in evaluating the grant. And I like to tie these to the specific grant proposal provided by the grantee. And I like to attach that grant proposal to the award letter so that there's no doubt about what features of the grant are important to the funder. I do require that these grants be countersigned by the grantee and that the grantee agrees that they will adhere to the conditions of the grant agreement. And I also have a catch-all provision that says in the unlikely event that the terms of the grant agreement letter differ from the proposal, the grant agreement letter controls that term. So this is just good contract drafting that I'm talking about for a lot of these provisions. In this introductory language, I also include a clear statement about how the foundation should be recognized, if at all, in public communications. So here are the main headings that I cover in this grant. First, I specify the grant period. When does it start? When does it end? Next, I talk about objectives, deliverables, and reporting requirements. I want to be very clear in the grant agreement that these funds are to support the specific grant purpose that's defined in the introductory paragraphs. Next, I talk about the progress reports. For a multiple installment grant agreement, my template requires brief progress reports on certain reporting dates, which are usually the next installment is paid upon receipt of and approval of the interim grant report or interim progress report. Then I also refer to specific requirements for a final grant report. The final grant report is required in my template to include a review of the grant's objectives and an assessment of whether those objectives were attained. I like to ask the grantee in this template to note factors that may have impacted progress, whether positively or negatively. The final report can have any sorts of features that the grantee wants, but in my template, I like to include some food for thought for the drafter when thinking about what reports will be appropriate under the circumstances. I also like to include a bullet point requiring the grantee to submit copies of work product, including graphics, white papers, articles and publications, anything like that that's related to this specific grant. Like the simple form of grant agreement, I include in this form that the grantee will notify the grantor of organizational changes during the term of the grant, including changes in key personnel, changes in public support charity status, and any changes in the grantee's status as a publicly supported charity described in Internal Revenue Code Section 501c3. That's just good grant form drafting. Next, I have a section on general terms and conditions. And here's the place where I have a bunch of optional terms. So if the grant will allow legislative lobbying within a project-specific grant, I always include, particularly for private foundation funders, that there's no agreement, oral or written, directing that the grant funds be used for any attempt to influence legislation. Specific details about lobbying grants are covered in other episodes, and I'll link to those in the show notes. The general terms and conditions also require that the grantee return to the grantor any portion of the amount granted, which is not used for the purposes of the grant that are described in the introductory paragraphs. I also include a reminder to address administrative charges. Some funders want to be very clear the amount of the grant funds that can be allocated for administration, overhead, indirect, or related costs. That often includes a standard provision that administrative expenses can't exceed X percent of the grant amount. In my template, it's 10%. That's not a magic number, but it is useful to have that in your form template as a reminder to consider the amount of administrative overhead that can be drawn from the grant funds. In addition, I often include in this long-form grant agreement the provisions that I talked about in the previous section for the basics for private foundations grants. That is, prohibitions on using funds to carry on propaganda or lobbying to influence public election of any candidate for public office, grants to individuals, and grants for activities other than the purposes described, the charitable purposes in Code Section 170C. These are the same boilerplate provisions that I mentioned earlier in the discussion of a private foundation general support grant. And then I want to touch back on the material support for terrorist activities. I have a long version form of that prohibition, and this is often useful for grant makers that are making grants to U.S. organizations that do operate internationally. So my long version template language prohibits the use of grant funds directly or indirectly to support activities, A, that are prohibited by U.S. laws, including but not limited to laws related to terrorism, B, directly or indirectly to activities with individuals, groups, or entities on the list of specially designated nationals, with a reference to the Treasury website for this specially designated terrorist list. This long form also prohibits grants and funding directly or indirectly to countries against which the U.S. maintains a comprehensive embargo, unless the activities are fully authorized by the government under applicable law and specially approved by the organization, by the grantor foundation in its discretion. So that's the long version, and in some cases it's really appropriate to include the long version. But most of the time we use the short version, which is just a prohibition that the grantee may not provide material support to any person or entity that engages in violent or terrorist activities or engages in any illegal activity. I also include in my template a provision that the grantee will not offer or provide money, gifts, or other things of value directly or indirectly to anyone in order to improperly influence any act or decision relating to the grantor or the project, including assisting any party to secure an improper advantage, basically an anti-bribery sort of provision. Then there's some special concerns for grants to foreign organizations, and many of these concerns are covered in a separate episode that talks about international grant making. So I'm not going to go over the specifics of the grant agreement for foreign grants because those are really well covered in that other episode. That's the basics of my template for project-specific grants. Now I want to move on to some suggestions and some components that I include in my template endowment agreement. An endowment grant refers to any grant that has a purpose that cannot be fulfilled in 1 year. Endowments can be perpetual, that is, intended to last in perpetuity, or they can be for a set term of years or for the duration of a particular program or project. Here are the additional components that I have in my template endowment agreement. So the form endowment agreement starts with a provision that describes the amount of the grant and the payment schedule, if there is a payment schedule. Typically, it may be just a single endowment grant for specific purposes. In the purpose provision, again, like my project agreement grant, I like to include a reference to the grantee's proposal, if there was a proposal for a particular endowment grant, or in any event to as much detail about the program to be supported from the endowment as is possible. This provision also typically names the program because that makes the drafting easier and also helps to support the discussion of marketing materials, websites, brochures, and catalog references to the endowment. I like to include a provision in my form that provides for additional contributions to specifically allow contributions to this endowment fund by the grantor or by others, as long as those additional contributions designated to this endowment are added to the principal of the endowment and the additional contributions don't contain any restrictions, conditions, or designations which are inconsistent with or conflict with the subject grant agreement. Then I also include a provision on change in circumstance. It's really important, particularly for organizations that are funders, either public charities or private foundations, to state what happens if the program is terminated or the purpose of the endowment is changed in a material way. When the funder is an ongoing charity or private foundation, there's no reason why the change in purpose can't result in return of the remaining unspent endowment funds back to the funder. That way, the funder has the option, the grantor can choose whether to allow a modified purpose as proposed by the original grantee or to simply take the funds back and determine how it wants to deploy them in the future. On the other hand, if the change in purpose clause can also provide for the grantee to repurpose the funds within the grantee's programs, subject to the approval of the grantor. Next, a very important part of endowment agreements that doesn't appear in our project support agreements are the investment and spending instructions. To understand these provisions, listeners might want to go back to the episode that discusses the Uniform Prudent Management of Institutional Funds Act. That's UPMIFA. I'll have a link to that in the show notes as well. So in our investment and spending instructions section of the template, I have a paragraph that describes the spending policy. There's several options here, and these are the options I include. First of all, in all circumstances, the earnings generated from the endowment are required to be used for the sole and exclusive purposes as set forth in the purpose provisions of the agreement. The first option is to include language that says to the effect that there can be no invasion of the historic dollar value of the endowment. So if the endowment was $1 million, the spending policy says you can spend money, but you can never invade that $1 million principal. So my language there is that the initial amount of the endowment and any additional contributions received shall not be available for expenditure regardless of default provisions in any applicable law. It's very important, if you really mean historic dollar value to never be invaded, to override the state laws, because the state laws, particularly the Uniform Prudent Management of Institutional Funds Act, does allow the recipient organization to some default provisions that allow invasion. But if you don't want invasion, you need to call that out very specifically. Option 2 in my spending policy section of the Form Endowment Grant Agreement is an option that allows an approved range of spending. So that language would read something to the effect that the approved expenditures shall be not less than X percent nor more than Y percent of the amount of the endowment fund as of the close of the prior fiscal year. And then option 3 for the spending language is what I refer to as the pure UPMIFA language. And that is that expenditures shall be made in accordance with grantee spending policy applicable to all endowed funds. So that gives the grantee considerable discretion about how to spend the funds. And they generally would follow the guidance in UPMIFA. And again, take a listen to the UPMIFA episode if you want more details about how that might work. So back to the grant agreement. My endowment grant agreement includes a discussion of the investment policy. Default language is that the endowment shall be invested with a view to long-term appreciation so that the purchasing power of the endowment is not eroded by inflation. Funders can get very creative with the investment policy. They can require investment in, say, socially responsible investments, or it can prohibit certain kinds of investments. There's really a great deal of flexibility, but it's important to address the investment policy in the endowment agreement. Next, like my project-specific grant agreement, I have a provision on administrative costs, just to make sure that everybody's clear, grantor and grantee, about the degree to which charges for administration, overhead, indirect or related costs can be allocated to the endowment earnings. I do have a provision that allows the investment and endowment management fees to be applied against the endowment earnings. And in that provision, I also typically include a statement that the endowment funds can be commingled with an endowment pool at the institutional grantee, which allows some flexibility and helps the grantee organization to simplify its investment program when the endowment is allowed to be commingled with the rest of the endowment pool. So that's it. Those are the special provisions that I include in my endowment agreements. And the last thing I want to talk about a little bit here is the naming rights in grant agreements. Naming rights can appear in project-specific grants and endowment grants. When the grantor wants the project grant or the endowment grant to include special name recognition as specified by the grantor, there may be substantial negotiation with the grantee. And so here's the things to consider when thinking about drafting in the provisions about naming rights. First, the specific name to be used. It may be the grantor entity. It could also be a founder or a key person or an honoree or a corporate name. In the case of using a corporate name or logo, the grantor may want to get permission from the company for the use of that name. So that's just something to check if it's a corporate name that will be used. Second thing to consider in drafting our naming rights provisions is when the naming rights take effect. Is it immediately? Is it after certain milestones are reached or contingencies are satisfied, or after the death of the individual whose name will be attached? Any of those things may be relevant to your grant agreement. Next up in negotiations is how the name will be displayed. This can be very specific, such as requiring that the name appear in a particular location on a building in letters of a particular font and size. Diagrams and renderings are often used to be very specific about how the name will look, and this can avoid later disputes, particularly when the funding is for a building program where the name will be permanently affixed to a structure that will last a long time. In other circumstances, the naming right goes along with a program, maybe an endowment fund, things like that. So the provision that addresses what the name attaches to can be very important. Charities sometimes have very elaborate schedules of naming rights that are offered in and around a building or associated with a program or department for which it has an endowment campaign underway. So the grant agreement for our grantor may need to be very clear on the extent to which the naming opportunities will be offered, and might want to specify that no other naming opportunity will be afforded a more prominent treatment if our grant is the largest grant or the key grant for the program or building. So all these things are very much negotiable and something to think about at the outset, particularly when the grant goes towards a fundraising campaign by a charity. Next, what happens if the building or space that's named is destroyed and not rebuilt, or simply torn down because it's become obsolete? Here, it's very helpful to include a term for a naming right. Nobody has a crystal ball, and 50 years into the future is a long time. Lots of things can happen. So sometimes the best thing to do that serves everybody is to simply say that the naming right has a duration of X number of years. Then after that term, the grantee institution, if they build a new museum or a new wing or whatever, they have the flexibility to use naming rights to raise future funds without being hampered by pre-existing, sometimes vague commitments to previous donors for buildings or spaces or programs that are no longer being continued. So let's think about that up in the beginning when we draft the grant agreement. Another provision in the naming rights discussion is the publicity regarding events at the building that use the name of the building. Is the name of the building always required in publicity, or is that something left to the grantee's discretion? Does the name have to be used in the formal address for the building? Will the building be formally opened with a ceremony at which the individual for whom it's named will have the right to speak or attend? To what extent will the grantor or others have the right to pre-approve promotional materials involving the name? All of these things have come up in grant agreements, and some of them have resulted in litigation. So the more specific we can be and the more clarity there is, the better, particularly if it's a very large grant and a very meaningful building or program for the recipient charity. We talked about time limits. Another thing to talk about is morality clauses. More and more often, the grantees are seeking to put time limits on naming rights and also to ensure that they have a way out if the circumstances change. In particular, if the name on the building or the program becomes a source of concern or embarrassment. As we talked about earlier, remedies for violation of the agreement when the grantor is an organization, a private foundation or a public charity that expects to be around for a long time. The easiest way to draft a remedy for breach of the agreement by the grantee is to require reversion of the funds, any remaining unspent funds, to the grantor charity or foundation, as long as it's in existence. Or if that organization or charity may not be in existence, you may want to provide that the transfer of the remaining funds goes either to a specific other charity or a charity with a purpose similar to the funder or grantor. So that's a lot. I've covered a lot in this episode. Be sure to check out the show notes for links to the other episodes I mentioned that are relevant to grant making, and you can find these on the Farella, Braun, and Martel YouTube channel. There are a number of playlists there, so enjoy browsing to find topics of interest to your organization. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun, and Martel. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.